Welcome to Simplifying the Complicated. In each episode, we'll get together with other professionals and have fun talking about trust and estate matters. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Now here are the hosts of Simplifying the Complicated, Lori Bolander and Lauren Gallagher.
Oh, I'm Lori Bolander.
And I'm Lauren Gallagher.
Welcome to Simplifying the Complicated, the show where we talk about trust and estates issues and related topics. Today, we're going to simplify some issues around trust and estates litigation. And we're going to welcome our guest, Eddie Broitman, from the law offices of Edward Broitman. Eddie is a trust and estate litigator and has offices here in San Diego and also in the Bay Area. His office in San Diego is quite close to ours, in fact, within our actual building. Which is actually nice. Welcome, Eddie.
Hi, nice to be here.
Yeah, thanks for being here today. Lauren and I do no litigation at all. We stick to just the planning and administration and probates, which is why it's so great to have you in close proximity so we can help. You can help us figure out some of these litigation issues before they arise. Before we kind of dig into all the issues, when I was looking at your bio this morning on your website, I saw that you said that you enjoy third wave micro roasted coffee, and I just have to know what that is.
Basically at this point, it's just coffee from a local coffee roaster as opposed to from, like Starbucks.
Okay, cool. I just was like, what is third wave? Is this like a new thing that I'm missing out on?
I think I'm late, actually. I think there's probably fourth wave happening already, so I might have to update my website. So, yeah.
Well, I did not miss out on my coffee today, and so hopefully I won't get talking too fast today. I'm pretty caffeinated.
Right.
So one of the questions we were going to start with is, what are some of the issues you see most commonly litigated?
Right. Yeah. So I think on the surface, the main things that seem to pop up all the time are allegations of undue influence, where somebody's, someone close to the person is possibly, sort of influencing or changing so that, they get more of a benefit than other family members or other close people. And so that, I think on the surface, that's kind of one of the main bigger legal issues that pop up. But on the more, I'd say, kind of day-to-day level, I think the bigger part, or the part that I see the most, are basically usually accounting disputes where somebody's responsible, like a trustee or personal representative in an estate. And, there's issues of, with the accounting, how money was spent. Is it just straightforward, where there's questions about what should have happened and didn't happen, or are they more, interesting, like, is the trustee going to the beauty salon, and, why is that a trustee? Right. Yeah. But it is important. So that's, I think, one of the main ones that I see on a day-to-day basis.
Well, I mean, when you say when you raise undue influence, then like accounting issues, those are kind of on the two separate ends of the spectrum, which we were going to I was going to get into later, because the undue influence is kind of more of a planning issue, right? Where during the estate plan, the person alleging undue influence is saying somebody's influenced the trustor to change their trust. And then on the accounting side, it's more like trustee actions. And on the undue influence side, I know I have a lot of people that call me, saying somebody's unduly influencing, mom or grandma or dad or whoever it might be. Or is there like technical definition or issues that, really have to be met in order for that to actually be the case legally?
For undue influence, yeah, there's certain legs that need to happen, but essentially is somebody, receiving an undue benefit, and is the free will of the, trustor or person whose assets there are, is it being changed? So, I guess the common example is, why was there a change made that went from all the kids getting something equally to suddenly one of the kids getting, everything. But, that could be legitimately what the person wanted. And it could be that that was the kid that was around and, gave their time and showed their love, and the other people weren't around. So I guess that's why the lawyers get big bucks in that situation, because, it's not clear always. And it could be that just because the facts are a certain way, it could be the right way. It doesn't necessarily mean because there's a lawsuit that actually somebody did anything wrong.
And with undue influence, is like capacity usually raised as well, or does it often go hand in hand?
Yeah, it's usually raised. But, I think that's more it certainly can be argued, but a lot of that just kind of comes down to the medical record. So it is usually raised together, but I feel like in those situations, the sort of more litigated piece is usually with the undue influence, and there's a lot more of a gray area and a lot more room for facts and evidence and the particular situation.
Yeah.
I think people, when they hear that, especially older parents, that makes them panic, because they do oftentimes have one child who cares for them the most, who's there for them. They
Right.
dial their daughter's phone number, and they're going to answer. They're going to be there no matter what. And those situations sometimes are completely legitimate. That was the one that I could always rely on, and my other daughter never called me, or
Right.
my son never came to visit. Haven't talked to him in 10 years. So, what do you say to us planners who have that situation with our clients, who kind of struggle with, wanting to carry out our clients' wishes, but on the other hand, see down the road that could potentially lead to some litigation?
Right. Yeah. I think, the only thing I could think of that would probably be helpful would just be being as specific as possible in the documents, of not only saying it all goes to this particular kid in that situation, but maybe even adding a few more sentences or details as to why, so that there's already, something there. Because for me, one of the other things that, seems to just pop up a lot in this area of law and in these cases these are just basically disputes between siblings a lot of times. And it's playing out the family drama of, from when they were little or when they were teenagers and all the way up to them being adults, where, especially when one of the children are the trustee and kind of have a little bit more power and control, and then the other siblings are along for the ride. And so suddenly there was a huge power imbalance.
Often it's the trustee is also that sibling that is receiving everything as well. Yeah.
Yeah.
Let me ask you, because I've done this, is it helpful in those situations to sometimes have the client write something in their own handwriting about the details of why they're making the change?
I think that's helpful. Any evidence that goes to the details and the specifics is going to be helpful. But of course, it depends on the claim. If we're talking about an undue influence claim, I think, it's helpful. But the bigger piece there, which seems to pop up a lot, is, how did that trustor or person find the lawyer that's doing these changes for them? If it's the so-called, bad actor or the undue influencer that made the phone call or drove the person to your office, that's, those facts are usually negative facts. And so I think maybe sort of describing those details in the documents or in this writing is helpful. And just for planners to, to be clear and to know that, yeah, it might be easier to set the meeting up with the child or email the draft of documents to the child, but that's all evidence that comes up later that goes to these, undue influence claims.
Yeah. Well, I used to know this kind of nuanced part of the law, but when our client dies, then essentially our file is kind of open if there's litigation. Pretty much everybody can see everything. Isn't that the law kind of presumes that that's what our client would want, because, there's a dispute and they would want everybody to know all the things they told us.
Yeah, the evidence code has an exception where, essentially what would have been that client's attorney-client privilege it's excluded, or there's an exception there that goes away. And so because it's such the crux of the dispute in these type of situations, that the files are kind of opened up to the parties on both sides so that it's clear, what, if there's anything helpful. So that's another piece that might be helpful, is maybe behind the scenes in the estate planning attorney's files, maybe some detailed notes about the meeting and their reflections about, yes, on the surface, it might be weird that it's all going to one kid, but this really is what the person wanted. And these are the reasons why.
Mm-hmm. And we're seeing more and more third-party trustees, clients wanting third-party trustees, not their children, even families where everybody seemingly gets along. It seems to be becoming more commonplace for all clients, all types of clients, to want a third party. Are you finding that to be helpful, where your client, the trustee, is also not the accused bad actor? Or needing to be, to defend that trustee, bad actor child from being removed as the trustee by, another child?
Yeah, I think in general it is, if the, the challenge with getting a fiduciary or a neutral trustee is usually just that there's enough assets, for them to come on board, because they are more expensive. But if that is possible, and the trustor is willing to do it, I think it's a great idea, because another sort of area of disputes that are almost a given is, the situation of all the kids are the trustees and all the kids are the beneficiaries. And so it's a given that there's going to be, sort of disagreements, which a lot of times lead to court. The case that took so long to deal with, that I was involved with, was 6 children that were all co-trustees, co-beneficiaries.
Wow.
And on the surface,
we would never allow that to happen.
No.
Right, it shouldn't have, but that's what did. And it went to the parents wanting all their kids involved and all their kids being equal, and I think they just figured, we'll let them work it out.
It's an area that's difficult to explain to the clients, because that's what their reasoning is like, well, I want them to have equal control because they're both the beneficiaries, and they should be able to do everything together. And part of the way I kind of am able to steer them away from it is by saying, like, well, just logistically, the trustee has to sign a lot of things. They have to go to banks personally. And if they both have to do everything, it's just too much, Right. So that's how I've been getting away, because Judge Kelledy, who's now Justice Kelledy, I know she had implored us numerous times to not appoint co-trustees, especially family member co-trustees. Yeah. And, I tell my clients that, but sometimes they still insist. And so sometimes it still happens. But that's one of the ways I try to deter that with the co-trusteeships. But, going back to the fiduciary, the professional fiduciary thing that we were talking about a minute ago, it seems like that's a benefit if we can talk our client into it, because sometimes I've seen cases where it's like the bad actor child is the trustee, the only beneficiary, but then the notification doesn't even go out. And sometimes they might not even tell the other siblings that mom and dad have died. Mm-hmm. And so at a minimum, you at least have that level of compliance with the law if you have a fiduciary in there, assuming they tell the fiduciary that they passed away, I suppose, too. But seems like that can alleviate a lot of battles by having a third party in there.
Right, a lot of battles, and also it just makes sure that things are going to get done properly, because there's a lot of work that goes into being a trustee, especially dealing with selling properties or renting properties, and the taxes that have to get done. It's like all the different aspects. It's a job that requires a lot of time and energy.
Yeah. That's another thing we're always trying to explain to our clients. They think they're giving somebody this honor of being the trustee, and I'm like, this is not an honor. This is a job.
Yeah,
why they can get paid for it too, by the way.
Yeah, because I get involved a lot when there's actually a dispute. Most of the trustees in that situation have said in the middle of it that, if I would have known it was going to be like this, I wouldn't have accepted the job, or I wouldn't have even done it. And a lot of times the the sibling relationship has suffered because of it, might not be able to be fixed, and so, yeah, if you have a neutral person doing it, then none of these children are going to be the bad guys or the bearer of bad news, or, sort of having to deal with this other job.
And some people, sometimes they're on their better behavior, not best necessarily, but better behavior when there's a stranger or, professional, because like you said earlier, all those family dynamics aren't at play, maybe behind the scenes, but they might be less apt to attack a neutral trustee that they don't know versus their older brother who's always, treated them poorly. So there's that.
Yeah, there's that piece of it. And also, if they start to see that every time, they ask a question to the trustee or the trust attorney, and they see that, it's suddenly, hundreds of dollars just for these questions, they're a little bit, and, indirectly that's coming out of their share. They're a little bit more thoughtful maybe, or, aware of not just trying to sort of, I guess, muddy the waters unless there's really a legitimate reason to.
Mm-hmm.
Yeah. So where I was asking you, like on the planning side, what can we do to help avoid litigation? But on the administration side, we're talking a little bit about avoiding some of these situations altogether. But as far as like trustee clients, like what are ways that as attorneys that advise trustees or probate administrators, what are good tips for them avoiding litigation?
Letting the attorneys sort of drive the administration, and let the trust attorney decide what the trustee should or can be doing to save time or save money. A lot of the problems end up being when the trustee takes matters in their own hands, whether it be with tax forms or tax documents, or in dealing with some of the assets. And so while some I guess some trustees can handle it and do it well, others end up making mistakes that end up costing more time and money if the trust attorney would have just handled it initially. So
one of the things we struggle with our individual trustees is convincing them that a formal, and when I say formal, it doesn't have to be a probate formal accounting, but a proper accounting should be done in every case. What are your thoughts on that? I would imagine you mentioned at the beginning, some of your kind of everyday cases are just questioning the accountings, and we get turned over accountings from our clients sometimes that are handwritten notes, and they don't make sense. They're not even in the format we've requested, and it's hard to convince them sometimes that that's not good enough.
Like, it's all here. And it's like, right, but it's going to take, a detective to put all the pieces together. Like, I can't even present it to the beneficiaries, let alone they understand it,
Right. Well, if the family situation and the trust administration is really as smooth as, the parents want it to be, then in that situation, we normally get waivers of accounting. And so that covers that area. But if that they're not going to be signed, or, any one of the beneficiaries is wanting a detailed accounting or wanting more information, it's pretty much a given that an accounting is going to need to get prepared. And so
I always wonder about the waivers though, too, because I had a case one time where somebody revoked their waiver later.
Right.
And it was like significantly down the road. And I suppose they have the right to do that. I mean, I put on my waivers of accounting that they're revocable, but what does that really mean? I guess it's just, at the time they signed it, they knew what they were getting into, but I don't know that a judge would necessarily hold them to that.
Yeah. I think they can be revoked. I think that's very rare. And so, in that situation, then you would have to sort of go back into accounting mode.
Well, and the other concern I always have about that, and this is why I usually tell my clients we should do some sort of informal accounting, is that if they waive the accounting completely and you haven't showed them like everything that they've done, then any sort of release that I think you get for your client may not really be valid, because, you're not saying, here's what I did, approve it and release me, right? So those are just always kind of concerns I have when clients want to waive, and sometimes they've showed the beneficiaries all the bank information all along. So I feel okay with it, because I'm like, well, I know they saw that. I prefer to have them acknowledge that in writing, but
yeah, I mean, I think if I was representing a beneficiary in that situation, I think it doesn't make sense to just blindly sign the waiver. I think normally, yeah, they would have at least access to some account statements or, some data to at least see that, it's worth not going through the expense of preparing an accounting, or sometimes it's just real property and it sells and everything's coming out of escrow. So it's a little smoother.
Yeah. Yeah, exactly. So how long if you're in a litigated case, I know that might vary, but how long do they typically last?
I mean, once the court's involved, then, just even all the preliminary stuff takes takes at least, I'd say, 4 to 6 months of just by the time you get a hearing date and get an initial hearing. So, I tend to tell my clients that if, the court's involved and this is happening, it's going to be at least a year or two, if not longer, until there's actually some sort of ruling. But it's specific to the case and the facts and the situation. And, the truth is that when there's litigation and there's two attorneys involved, the personalities and sort of actions of the attorneys really drive the cases. So if there's somebody that's more aggressive or taking stances that within the courts, then that sort of drives how this goes.
I've noticed there's more attorneys kind of diving into this practice area. I mean, it's just, I think, we're all really busy. All of our colleagues are really busy. All the professional fiduciaries are really busy. It's just kind of, this practice area has just been really busy. But now, because of that, you're getting kind of larger firms that are more litigation focused coming in on some of these, litigation cases and being quite aggressive in some situations.
Yeah, definitely. And so, I'm a solo practitioner, so, I kind of handle all aspects of my office, and I only do this area of law. And so there are many cases where a lot of the sort of civil tools, the civil litigation tools, like, discovery and depositions, in some of these matters, it doesn't even come up. Whereas in a civil matter, it's a given that, written discovery and depositions are going to happen. But there are, because we're allowed to use those, sort of in our cases, they do pop up. And yeah, if it's a firm that specializes in litigation or specializes in, civil litigation and then comes on board, it's almost a given that they're going to do some of these discovery actions, even though they're not necessary, might not lead to any valuable information, or just simply ways for them to bill their clients, for work.
Written and discovery and depositions and things like that really drive the costs up as well, right?
Yeah, they drive the costs up on every level, and especially when it isn't just providing documents. It's like it's pretty time. A lot of time goes into preparing these responses. Then there's the potential of discovery disputes that go to court, fighting over these issues, and then suddenly a lot of legal, time and expenses have gone into these preliminary matters, which I think makes sense when some of these firms' clients are, insurance companies, and, that's just these big document, sensitive areas. But when it's just sort of, one individual fighting with, their siblings, it really can make a difference of how long these cases take, or how expensive these get really quickly.
So does that sometimes, as it moves along, there are people who are just going to fight to the bitter end, right? They don't care whether all the money's gone. It's a little hard for some of us to understand that, but there are people who are willing to do that. But in your cases, do you find that the majority, once they realize how much money is being eaten up, in this process, they say, I better just, take what I can get and we'll settle and we'll move on.
Yeah, I mean, it's really particular to the situation, to the people. But there are sort of, moments in time when people see how expensive this can get, or where it goes. But yeah, you hit it, that it's true that there's some people that, and they'll say it to out loud and to anyone that wants to hear it, that, they'll basically rather have nobody get the money, or as they say, the lawyers get the money, than, their sibling or party on the other side get it. And so, it's really driven by the personalities of the party, the people that are sort of at play in these different roles in these cases. But I will, sort of segue it with, I'm all about mediation and trying to settle these cases, because it's very rare that it's so black and white and sort of cut and dry that, like, it's there's always sort of these gray areas or these facts that could go either way, or sort of, tough interpretations of the law, or there isn't case law that goes with it. So you're taking a chance, and you're taking a chance anyway, because we don't, our matters are decided by one probate judge. They're not jury decided. And so you're putting everything into a judge's hands. And there's definitely been, shocking rulings that, perplexed everybody that were involved.
So either way, I know I've had clients say, well, why don't we videotape this? But I remember there was a case that I must have been in a continuing education that I went to or something, where they were talking about the use of this video, of the trustor signing the trust. And, the attorneys completely picked it apart, because they were like, well, who was in the room? And, how long were they there? And
right.
What did they do that day? And were they on any medication? So it's it almost made the case worse, because there were so many ways to pick apart the video.
Right.
I know,
Yeah,
it seems so logical to do that, though, right? Let's
right.
Mom or dad isn't going to be here in the end, so let's get them on tape right now,
right.
And that'll solve all the problems. But that doesn't.
Yeah, I guess for a good lawyer will come up with things to question about the validity.
Well, now you have these deep fakes, right? You can deep fake mom or dad saying, yep, you're my favorite child and you're getting everything.
Yeah, that's true. So,
I couldn't do it personally. Right, luckily, I'm an only child, so hopefully that'll work out for me. But
right. Yeah. Well, that's unique. And so the other thing that I see a lot of, kind of the opposite of being the only child, is a really common sort of area of stream of cases that I'm seeing is, the second spouse and children of the first marriage. And so that's a very common sort of area of a dispute. And it's almost just natural at that point of, if someone dies, do their kids get it? Does their second wife get it, or second husband? And so it's almost just like a natural area of conflict.
Absolutely. I have a couple cases where I'm representing a fiduciary where surviving spouse has been removed as trustee of the irrevocable trust, the B trust, after litigation. So we weren't involved in litigation, but now we're in charge of this money because, mom's kids didn't trust stepdad, or whatever the case may be. And so now we get to deal with it. And, again, that adds a whole nother, after the litigation, which I heard one party spent $115,000 on. So after the litigation, now they get to pay, my client to manage the money for the rest of his life, which seems crazy, but that's definitely an area that is fraught with litigation.
Yeah. Right. Yeah. And, and what we're talking about is, we're focusing on the pieces where there is a lot of litigation, but even when there's not litigation, it's like the administrations also need to be managed and happen and go smoothly. And so,
yeah, we see that a lot. This, when there's a division in the trust, the A and the B, one spouse dies and you have to divide it into two trusts. What will happen is nobody ever tells us spouse died, and surviving spouse comes in 5-10 years later, And we look at the trust and go, you were supposed to make this division. Oh, I didn't know.
Right.
And a lot of people literally didn't even know they were in an AB trust, didn't even know what an AB trust is. So I'm always telling, clients, if something happens, you need to call me, because that, and then what do you do at that point? Like, some of the damage is already done, right? As far as you can retroactively fund these trusts, that then you're, up for, arguments about values of things and what should have been allocated where, which I guess are always issues, but especially doing it retrospectively, it just leads to a lot more problems.
Yeah, I mean, every sort of fork in the road is a potential area for dispute or conflict, or the need to try to resolve it. And so I guess that's why, this area of law is so, all the practitioners are so busy.
Yeah.
It's just,
I've had more and more like younger couples, because one of the reasons we did the AB trust for a long time was for estate tax planning. The exemption is so high now that most people really don't need the AB trust. We have it in there as an option. But I'm having more younger couples, after seeing a fight like that with their own parents or, somebody else's, saying, we're concerned not about, somebody getting remarried and having another set of kids so much, but just like if the survivor loses capacity and is subject, by a caregiver or whoever else to, being unduly influenced, it's like, well, let's at least lock up half of it so we can protect it. But it's much, the main concern, I feel like, state taxes, and then the second marriage is always like the big catalyst, people being afraid of that. But now I'm seeing more like, well, I've seen somebody just get taken advantage of because they, had dementia or whatever the case may be.
Yeah. Right. Yeah. But in those situations where you end up like, making some of the assets or half the assets irrevocable, a lot of times the surviving spouse doesn't want to be put in that situation of having some
Absolutely
constraints. And so it's not an easy decision or an easy solution.
And an attorney I used to work for used to say, it's usually the wife that's pushing for this trust to be irrevocable at the first death, but then they always outlive the husband, and then they're stuck in this irrevocable trust.
Right.
It's a pain in the butt.
Right. Yeah. Yeah. And I think, in the big picture, I think, something that from in talking to you guys, like a part that I'm a little bit surprised of, but I don't know what the solution is a lot of times, some of these trusts are, the short ones are 20 or 30 pages and the long ones are, 100 pages. And so it just takes, a signature and a notarization, and suddenly these documents are, contracts are valid, binding things. And a lot of times, like you'll hear some of the, spouses say, oh, I didn't know that that's supposed to happen, or I didn't read this, or,
Yep.
So it's like, it's just a little bit surprising how easily these could be valid and binding. And then the aftermath.
And that's a little frustrating as a planner because, I go over things so thoroughly with my clients. I go over each provision often, and they're like, yeah, we get it. And they sign it. And then 5 years later, they come back and they're like, we don't know what any of this means.
Right.
I'm
Yeah.
like, okay.
Right. Yeah. Or in the, even in the, especially you had the, sort of the storybook ending where, suddenly the documents irrevocable 40 or 50 years later. And so it's like, no one's going to remember it, even if they are aware or on top of it at that point. So,
yeah, right. Exactly.
Yeah. So all of these are just areas and reasons why, there's always work for us, I guess. So,
we have job security, huh?
Yeah.
Yeah, exactly.
It's recession proof. So, I guess.
What do you think one of your craziest litigation stories is?
It's kind of a trivial thing that pops up initially. It's just, it's like the stereotypical, like there was a family that was really like, in the end, they were fighting over mom's refrigerator and who was going to get it, and how we were in the middle of a mediation, and then like it fell apart and we had to go to court, and eventually a judge had to make a ruling because it was clear there were four of them. We were going to, split everything up in fourths, and the assets were going to get split, but like they just couldn't. They really were fighting over who was going to get this fridge, and you can't divvy that up. And so,
Was it a nice fridge?
you know, I never. I mean, for me, it was. I don't even know it. You know, my hourly rate was probably worth more than what the fridge was at that point. So
Yeah,
but it was Mama's.
Maybe
fridge,
Mom
and
hid
everybody wanted it.
Maybe Mom hid some cash in the back.
Maybe there was more too. Yeah. But interestingly, that case was also the same one where the trustee that, you know, I petitioned to, or on behalf of my client to get removed, she was the one that was, there was charges in the trust accounting for going to the, you know, the hair salon well after Mom had died. So, you know,
yeah, I've seen that in some accountings too, where it's like, okay, that makes sense, you know, as long as Mom's alive. And then it's like, wait, after Mom dies, this doesn't make sense anymore.
Yeah, that isn't Mama's hair that's getting done. So,
Yeah.
So I don't know. They're all interesting. They're all interesting in certain ways. Like they're all just crazy people involved and crazy family dynamics. And so, you know, it's like they're characters that we get to know really well for a certain amount of time.
I know we have a lot of clients who sit down and they apologize for how bad their family is, or how, you know, you must think so poorly of me and my family. I'm like, we all have families. Everybody has their own dynamics.
Right.
I see a lot of them. I'm not going to judge yours. They're just interesting in a different way.
Yeah. I just saw a quote that like there's this place that always puts up these funny one-liners. And it was like, basically everybody's normal until you get to know them. So, yeah.
Yep.
Exactly. Just like everybody hates attorneys until you need one.
Right. Yeah.
Yeah. Well, we have all kinds of characters, and it's like something we could like train our new staff on, which we just hired some new staff. And it's like, yeah, you're going to get some people that are just going to wander in and, you know, demand things and maybe talk crazy. And that's just part of your job.
Right. Yeah. Well, it's like there's the financial aspect, but there's also the emotional aspect. So we kind of get thrown in the middle of the whole.
Definitely.
We are in the middle of the family drama. So.
Yeah, it's definitely an area of the law where like the term counselor at law like really is apt, because you know, you have to counsel your clients literally sometimes. You know,
for sure.
it's
I've actually come across a few, you know, attorneys that are actually also, you know, do have our therapists also, like I have the training for, just because there's such a overlap. So
yeah, there really is. It's so interesting. Well, I think we might be getting close to being out of time. That actually went by like pretty fast. Yeah. So, yeah, I know. And thanks for, you know, giving us more information. You know, avoiding litigation is something we're always trying to do. When I tell people when we're setting up these estate plans, like, look, these documents, and they're all in their own ways and all together. You know, all the provisions in here, we're just trying to avoid to go to court in these various ways. You know, whether it be for probate or conservatorship or litigation, or, you know. It's like we're always trying to avoid court, and, you know, it's good to hear a little bit more about, you know, exactly what we're trying to avoid.
Right. Yeah. And somewhere along the way, most cases do settle, like whether it be right at the onset, you know, or even up to the point of getting ready for, you know, a trial or an evidentiary hearing. It's like the majority of, at least the ones that I'm involved with and that I've come across, are one point or another, they do settle. It just makes both, you know, it makes financial and emotional sense to just kind of close it off.
I think I saw something somewhere one time that said like 98% of all cases, criminal, civil, whatever, they all settle.
Right. Eventually.
I thought that was interesting.
Yeah. And the judges are pushing it a lot. You know, because I have my Bay Area office, I am exposed to, you know, sort of different counties and the probate judges at those counties. And I could say that the San Diego judges are, you know, almost, you know, they're really pushing for trying to go to mediation, trying to settle before it's getting into their hands of actually making any decisions.
Yeah, because they can actually order mediation now, right?
Yeah, you can order it. And now there's this, you know, sort of new case that came about, the Breslin case, where even if you don't want to go, if you're noticed of it, you know, you either have to participate or you're bound by the decision. And so
Yeah.
It's kind of really allowed the judges to, I think they've used it as a tool to try to, sort of get the parties to try mediation before, making any decisions.
Even seen some cases where I'm not litigating, we're just the trustee holding the money while everybody else is litigating, that they've been to been ordered to 2 mediations or mandatory settlement conferences. And, I didn't think that used to be normal, but it's seeming to be more and more normal now, where the judge is like, we'll try it again.
Right. Yeah. Or just sometimes through the private mediators are doing it in steps because, some cases are a little bit more straightforward where, there's one core issue where you're sort of dealing with, but others where there's many issues and different angles and, many parties involved. It's like the time goes really fast where you're suddenly 6-8 hours into a mediation and, you're not settled, you haven't settled yet. And so either you stay, through the night and, you're hungry and agitated and, all that, or you actually just, sometimes it just makes sense to have everybody come back, and continue it.
Exactly.
Yep.
Cool. Well, thanks again for being here, Eddie. It was great to have you today.
Great.
And thank you everybody for joining us and Simplifying the Complicated today. You can find out more information and get in touch with Eddie by going to his website, broitmanlaw.com. And you can, of course, contact us through lawgbs.com or by calling our office, which our number is on that website. So hopefully we have simplified some of the issues around litigation and how to avoid it today. But this has been Simplifying the Complicated. And thanks for coming today.
Thank you. Bye.
Thank you. Thanks, Eddie.
All right. Bye.
You've been tuning into Simplifying the Complicated with your hosts, Lori Bolander and Lauren Gallagher. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Thank you for your positive feedback, comments, questions, and for sharing this show with others.